tranquilo que eu te mando no WhatsApp se tiver alguma.
Ok. Na hora que vocês quiserem.
Pode começar.
So, if you want, you want me to start, or?
She's gonna present you. She's gonna introduce you, Professor.
Recording in progress.
Okay.
Hello, everyone. My name is Maria de Lourdes Albertini. I'm a professor of international law at Catholic University of Minas Gerais, Brazil, and at CEDIM. First of all, I would like to thank CEDIM to invite me to be here hosting this lecture, and Professor Amina to invite me to be here also. I also would like to compliment the Konrad Adenauer Stiftung for the event. Today is the third day of our 15th edition of the CEDIM International Winter Course, and we will have the great honor to hear Professor Yenkong Ngangjoh Hodu, who is a professor and chair of international economic law and head of the University of Manchester Law School at the University of Manchester, UK. Beyond the academic world, his expertise is highly sought for the governments around the world, United Nations agencies, WTO, and other NGOs for legal advice. His specific areas of expertise includes, but not limited to, the law and policy of WTO, international investment law, international monetary law, international energy law, the law and policy of regional integration, as well as public international law, broadly speaking. He has written many books and many dozen articles and books chapters on international investment law, WTO law, and public international law in general. Professor is also regularly consulted by many governments, regional organizations, and United Nations agencies on international trade and investment law. He has also been counsel for countries before international dispute settlement bodies. He is a barrister and solicitor and a member of many influential academic and professional organizations, and he is a counsel at Fortier Law Firm in Geneva. He has also currently on the roster of WTO panelists appointed by WTO dispute settlement body. In 2013, he was nominated for the WTO appellate body membership, the highest judicial body of the organization. Professor Yenkong is also part of the global faculty of the Trade Policy Center in Africa, TRAPICA, based in Arusha, Tanzania, where top officials from Africa and beyond regularly receive training on international law and on the political economy of the world trade system. Apart from having also spent many years working in Finland and Sweden, he has been visiting professor to many universities in Africa, Asia, Europe, and North America. Well, after this brief presentation, I'm sure that we will have a memorable morning or afternoon talking about rule of law and international trade law in the era of delegalization. Professor, it's a great pleasure for me to meet you here, and please take the floor.
Okay, thank you very much, Professor Albertini, and thank you for the very generous presentation and introduction there. And thank you to your center, the International Law Center, for inviting me. And I'm saying this also on behalf of the University of Manchester for inviting me to present at the 17th Winter Law Program. So I think, again, I congratulate you for having rallied very eminent international lawyers to your program, to speak to your program. And I look at a bit more about your center, and I think you share very, very concrete good values that in terms of bridging the policy and the research gap, kind of bringing contemporary issues which has always been written in the more theoretical way to some policymakers and to common people in the society. I think that is really a commendable task, a commendable objective, which I think, as your mandate says, will lead to world peace and security. I think it's that kind of understanding that is very relevant. When I was invited to present at this conference, I think I have in mind, it took me a while, which actually Ms. Lena can confirm this. It took me a while also to get back to you with my topic, because I had quite a few topics in my mind that I was just contemplating, the one that I should talk about. Although one of the reasons was also the busyness of my schedule, I think one topic that I had in mind was to talk about, I thought of talking about COVID because it's so fashionable. That's what is affecting all our life today. And then after a long contemplation about that, I just thought, well, I think it's been so depressing. Maybe it's better to move away from COVID. I talk about something that is also equally important. So that is why I came up with the topic of the rule of law and international trade law in an era of delegalization here. Delegalization here is more kind of being provocative. And the reason why I included delegalization here is actually just because what we've seen in the past, in recent years, at least we can say that in the past 4 years, it has been the issue of calls by some of the WTO members, or the imposition of unilateral measures by some of the WTO members against goods coming from other countries, against the trade interests of other countries. So some WTO members, major WTO members, have taken measures that are kind of, you think, counterproductive to multilateralism, which against the spirits of the WTO. So that is that context that I'm calling delegalization, because by the fact that countries are willing to take this measure on a unilateral basis without really going through the process that we have at the WTO, means that there's kind of an apology to those who call for unilateralism or for delegalization of the rules to allow countries to behave in the way they want, or to behave as sovereign states in taking decisions without taking cognizance of existing international rules. So that's what here I really call delegalization, because there's an intention by the action of states. We see that the states have an intention of delegalizing what they are partially legalized, so to say. And then of course, the concept of rule of law is not something new. I mean, I'm not inventing something here new in terms of the rule of law. But I just think I should offer some thoughts with regards to what is happening nowadays in the context of this rule of law. My presentation would be as follows. The first one will be, the first part, I will offer the general view of the rule of law as a concept and a bit of evolution. And the rule of law, secondly, I will also offer some thoughts on the rule of law at the international arena, or at the internationally, how the international community has seen rule of law, or what we could say as part of international the rule of law debate. And then the third one, which will really be the last one, although it will be a bit lengthy, would be the rule of law in the world trading system, which actually where this presentation got its title. And then also in the context of the rule of law in the world trading system, I will talk about the rule of law from negotiation or from norm creation in the WTO, or from rule creation in the WTO, how rule of law permeates the system. And the second one will be more rule of law in the context of adjudication, that is the dispute settlement in the WTO. So this briefly is what I will be talking about. And then of course, I will relate it to, again, what we have seen happening recently in the context of the international politics, i.e., what is happening in the US, for example, and other countries as well. So I think I will start with the substantive content of that rule of law, or the concept of the rule of law. So the concept of the rule of law is, just to be sure, I think I said I have 1 hour or something like that. Yeah, I may not use all this 1 hour. I may only use 30 minutes to 45 minutes, of this, and then we'll have more time for discussion.
Yes, please take your time, Professor. It's okay.
Okay, thanks. Yeah. So the concept of the rule of law is an old concept and dates back to 350 BC, when Aristotle and Plato wrote about the need for governance to be grounded on the rule of law rather than power. Yeah, the concept only started featuring in popular discourse when the Magna Carta was signed by King John of England in 1215, and subsequently in the 17th century, when the work of John Locke on the legitimacy of governance by law was published. But as I discussed below, it is the work of Albert van Dissé in the 19th century that actualized the phrase rule of law in his book called The Theory of Law. That is when he actually explained or brought up the phrase called rule of law. I mean, the previous work in the context of what Aristotle and Plato never mention the rule of law. Even the Magna Carta was just generally conceived as the origin, part of the origin of rule of law. They never mentioned that. So it's the work of Albert van Dissé that actually started using the terminology rule of law. So while there is no consensus on the definition of the concept of rule of law in legal scholarship, there is unanimity on the non-static or unsettled nature of the concept. The concept has divided opinion, and legal scholars have over the years put forward different ideas on how to ascertain the concept of the rule of law. For instance, Dissé in his 19th century classic attempted to determine the province of rule of law by providing some characterization to the concept. The rule of law, according to Dissé, can mean any of the following characterization. One, the absolute supremacy or predominance of regular law as opposed to the influence of arbitrary power. Two, equality before the law, or the equal subjugation of all classes to the ordinary law of the law administered by the ordinary law courts. And then three, and finally, the rule of law can only thrive where the laws of the Constitution are not the source, but the consequence of the rights of the individual as defined and enforced by the courts. So, end of quote. Although Dissé's thesis on the rule of law has been seen as the foundation of the concept of rule of law in English public law, it has been viewed with great disdain by critics. Critics submit that the concept of rule of law must go beyond the notion of equality as suggested by Dissé. They opine that what is illegal for private citizens should also be illegal for public bodies or their officers. Although Dissé's thesis and critics of the thesis were on the rule of law in Victorian England, it resonates beyond English borders. The concept is now entrenched in the legal thinking of many countries, including that of Germany, India, Canada, South Africa, I think Brazil, and so on. It is therefore submitted that rule of law has a universal appeal as a concept firmly embedded in human and the consciousness of every society. Moreover, due to its theoretical flexibility, the concept of rule of law has gained universal support from both national and international jurisdictions. It has become a universal concept accepted and practiced, albeit with wide variation by different municipal systems. It is not politically neutral and can sometimes be interpreted and applied in a manner that renders the whole concept meaningless. As Judith Shackler posited over 3 decades ago, the concept of rule of law has become meaningless thanks to ideological abuse and general overuse. And according to Joseph Ras, the concept of rule of law is, I quote, a mere slogan because of its vagueness. So Joseph Ras here sees rule of law as being so vague. I mean, it's something that is very kind of intangible and too vague to be concretized. So the concept is indeed vague and remains a contested concept, despite various attempts by legal scholars to lay bare its substantive content. What we can gather from this variation of perspective is that depending on a particular regime or political system, the concept seems to be oscillating like a pendulum, swinging to the right when a system is grounded on right-wing political ideology, and to the left when a system is constructed on a left-wing ideology. On the left, Marxism sees the rule of law as unqualified human good, while on the right, Hayek places the rule of law at the epicenter of development policy. At the international level, in 2005, the United Nations General Assembly recognized the, I quote, need for universal adherence to an implementation of the rule of law at both national and international levels, end of quote. This emphasis on rule of law was re-echoed by the UN General Assembly in its Resolution 67-1 of 2012, as well as in 2017. And although the phrase rule of law does not directly feature in the United Nations Charter, heads of states and government in Resolution 67-1 of September 2012 reaffirmed their commitment to uphold rule of law as a fundamental principle germane in further development of the 3 main pillars upon which the United Nations was founded, i.e. international peace and security, human rights, and development. And according to the World Justice Project, the notion of rule of law can only flourish where there is accountability, just law, open legislative process, and accessibility and impartial dispute settlement. However, my claim today is not about the politics of definition of what rule of law is. Rather, my humble submission in this presentation takes a very simple and yet pragmatic approach to the content of rule of law in order to demonstrate whether and how the World Trading System has internalized the concept of rule of law in its activities and procedures. And for the sake of this exercise, I will simply define the rule of law as a situation where everyone is equal before the law and where everyone acts according to the law, where institutions are grounded on legal premise and where there is access to justice for all. So this simple definition will help us to ascertain whether and how rule of law has been internalized procedurally and substantively in WTO law as part of international law. So I will now look at the rule of law at the international level. So as has been seen in the discussion above, it is important to point out from the outset that the concept of rule of law has gained prominence, mostly in the context of municipal legal system than international law. It has been cherished over the years as a constitutional principle within municipal legal system. Therefore, the extent to which we can employ rule of law in the interaction between nation states is not exactly clear. This lack of clarity is based on challenging relationship between the concept of rule of law and sovereign states, or the concept of sovereignty. There seem to be difficulties there in actually like bringing the two together. In other words, the challenging relationship between the concept of rule of law and the notion of sovereignty as such. Moreover, The fact that there is no such thing as separation of power in the form of legislature, judiciary, and executive at the international arena means that critics will doubt the existence of rule of law at the international level. That is always the old cliche and the old discussion of critics of international rule, talking about trying to compare international law to the municipal law by bringing these three characterizations in terms of legislature, the judiciary, and the executive as such. So in this regard, employing the concept in international affairs, especially in the context of international organizations that are outcome of interaction between sovereign states, will somehow entail a rather functionalist approach. So functionalist approach in terms of the way that international organizations operate. The rationale for such approach being the horizontal nature of international law as opposed to the vertical structure of national law. Because it's very easy at the national level to actually talk about the rule of law, because you can easily see the subject of national law, and you can actually state and legislate and kind of impose on the subject of international law based on the contract between individuals and the state, and based on the voting, depending on the system of government we are talking about. So this seemed to chime with the approach of the WTO, AGAT WTO, which recognizes the right of members to take, I quote, any action in pursuance of its obligation under the United Nations Charter for the maintenance of international peace and security. So that is really Article 21 of GATT, Article 21 of GATT 1994, as well as Article 14b of the General Agreement on Trade and Services. So it recognizes this link. So similarly, this functionalist approach is also reflected in different processes of the United Nations as noticed in the preamble to General Assembly Resolution 67-1 and Resolution 72-119, re-echoing the need for member states to uphold rule of law in order to promote the three foundation principles of the United Nations, i.e. international peace and security, human rights, and development. As a concept that emerges from municipal legal discourse, rule of law has been promoted at the international level through international law codification in the form of treaties, as well as international organizations. Such revitalization of the rule of law at the international level has been informed by functional necessity, as pointed above, rather than specific action to deal with specific issues of concern. Rule of law, from this perspective, is seen as a set of ideals ascertained, for instance, in form of rights respecting state, economic development, a particular market orientation, such as free market, etc. This so-called right approach is what Shackler and Dworkin see as rule of reason and rule of book, in quotes, models respectively. So can we then externalize the concept of rule of law into the area of international economic law, and in particular world trade law? Probably yes, as opposed to that. The language of the world trading system since 1995 is no longer that of ambiguity or that of nullification and impairment of benefits. The commitment of WTO members are referred to as obligations, just like any other international treaty commitment adjudicated by the International Court of Justice or International Tribunal for Law of the Sea. So now I'll look at the rule of law in the context of the World Trade Organization, where our topic of today actually got its title. So in this section, I will discuss how the rule of law, as presented above, impinges on the activities of the WTO from negotiation to dispute settlement. And the section will further discuss how the existence of a rule-based trading system has contributed to the evolution of international rule of law. Because this long-standing debate on international rule of law. What part has the World Trade Organization played in that? So is there a rule of law in the GATT WTO? Certainly yes, although many observers found it difficult during the GATT era to associate GATT 1947 with rule of law. A closer look at the negotiation process and GATT digital text made it difficult for this view to sustain. While from a practical perspective, GATT was a power-oriented system. The work of few international economic lawyers, for example, of Udek, John Jackson, etc., especially the Jackson's 1969 treatise on world trade law and the law of the GATT, made it difficult to claim that there was no rule of law in GATT. Indeed, GATT gradually emerged as the epicenter of international norm-making in the area of interstate commercial transactions. One of the advantages of the continuous legalization of GATT procedural and substantive obligation was the influence it had on the drafting of treaties that gave birth to new international economic organizations like the European Economic Community and the European Free Trade Association, that's EFTA, which is with headquarters based in Geneva. So GATT actually helped to influence the process of legalization in this organization. Although the influence of GATT as a rule-based system was not really visible in the context of GATT itself, because GATT was seen more as a power-oriented arrangement. I hesitate to use the word organization because it was never called organization as such. So emerging legal scholarship consistently argued for a need to strengthen legalism in GATT and to establish on a more permanent basis a rule-based trading system where unilateralism would become the thing of the past. It was therefore no surprise that at the conclusion of the Uruguay round of trade talks, the world trading system witnessed tremendous legalism. Consequently, the notion of rule of law is now uncontroversial in the world trading system since the establishment of the WTO in 1995. But what is rule of law in the WTO? That's a big question. In the WTO, the rule of law manifests itself through the way the negotiations are conducted, the approach in terms of the negotiation, as we will see, as well as the way implementation of obligation through the two-tier dispute settlement system is done. Of course, there's a question now on both fronts. Negotiation is at the moment suffering. We know that it's almost stalled now with only one so-called low-hanging fruit, which is the negotiation on fishery subsidies, which the ministers will be meeting tomorrow to discuss the draft agreement on fishery subsidies. And on the dispute settlement side, we know what has happened with the appellate body. We'll see that a bit later. So let's look at it from the perspective of negotiation. So the WTO is an international organization grounded on cooperation of member governments. As an international institution, negotiation is central to its overall activities. With the principle of sovereign equality of state firmly within the WTO legal architecture, every WTO member, as a matter of principle, I mentioned here as a matter of principle because this is a very contested subject, have equal status in negotiation. Any of the 164 members has access to all negotiation bodies. If you're talking about access, yes, there is equality there. Whether negotiation at the WTO happens at the ministerial conference, which takes place every 2 years, or at the General Assembly or different committees, each government has one vote. Okay, decision-making process in the World Trade Organization is also another issue in terms of whether the decision-making according to the two-thirds majority still exists. And more important to this process is the notion of collective legitimization that challenges or places limits on instrumental behavior rather than eliminating such behavior wholesale. So member governments who are primarily actors in these negotiations recognize that their interests and normative beliefs fit into the agreement that will emerge. I'm actually using the constructivist concept here, the constructivist theory in international relations. That's why I'm talking about normative belief here and interest, because it's very constructive approach to the discourse on international relations. So I'm actually borrowing from the international relations theory. And such negotiation, as exemplified by the Stall Doha development round, often encounter deadlock. The probability for deadlock increases when the sequence of actions demand or normative beliefs and interests of the member government lack a common denominator. Because the concept of normative belief here and interest actually putting together helps in the interaction between states in international relations as part of this discourse on constructivist discourse in international relations normally tells us. So apart from pressure from domestic interest groups not to give grounds on identified position to other member governments, the need to reach an outcome based on rule of law may also create an impasse or deadlock in WTO negotiation. Yet, negotiation between member governments are indispensable part of rule of law accentuation. WTO negotiation may therefore be conceived as expression of member governments' interests and normative belief. So the negotiation themselves can actually be conceived as an expression of members' belief and their interests, because the belief is actually first the belief in the system, the WTO system as an institution, and then the interest is actually the outcome, which is the treaty. So the fact that they can come together to see more legalization is an expression of that normative belief and interest. So it is against this backdrop that arguments have been put forward defending cooperation in the world trading system as a fundamental pillar of international legal order. Such cooperation in the case of the WTO has as its consequences norm creation as well as clarification of existing rules, because that is the purpose of negotiation, the failed Doha negotiation that has been happening. On the one hand, it is about clarification of existing rules, which have been very ambiguous and vague. And then on the other hand, it's actually to create new rules, move into new areas to actually catch up with the 21st century challenges. So in this regard, the rule of law manifests itself in the WTO through the process of norm creation by negotiation, a process of norm creation that is more rational than mechanistic. And the rationality of such process is supported by the fact that the economic and social concerns or interests of all its 164 member governments are to be taken into account and agreed upon as a package known as single undertaking in the WTO. I'm putting it differently. Through this cooperation, members of the WTO create rules that govern community. So that govern their community, that's a community of nations as such, Incremental legalization of international trade rules in the Doha development round of trade talks has seemingly been an obstacle to the negotiation process, because when countries continue to ask for legalization, there's like a lot of opposition somewhere. Some countries think, no, we shouldn't make everything so legal. We don't have to make everything so strict. As such, the stalemate in the talks has largely been due to the fact that the Geneva-based negotiators have consistently advocated for deals that can be drafted and construed in a manner that does not run contrary to the traditional definition of a treaty under international law, the one that everything should be watertight somehow. To the extent that negotiators ignore the notion of rule of law through binding obligation, any agreed outcome will fail to elicit legal obligation germane in sustaining the multilateral trading system. So I bet the current pressure to delegalize the multilateral trading system through the unilateral measures that countries have been taking, as I mentioned earlier. WTO negotiators are all aware that their interaction with each other must be governed by the rule of law, and any eventual deal must continue to ensure that international trade is conducted in conformity with agreed obligations. There has been three key subjects of contestation over the last 26 years, which have threatened in various degrees the future of the world trading system. I will briefly discuss this contestation in relation to the rule of law below, and also in the context of the WTO adjudicating body. And that will be my last part of the presentation. So the first contestation has been on how WTO members have behaved vis-a-vis the Uruguay Round Project. How have these members behaved vis-a-vis the Uruguay Round Project? What I really mean here is, how have they been respecting what was agreed at the end of the Uruguay Round? Because that is the first contestation, and this contestation actually lead us to what countries always feel that, where some countries always feel that other countries are not respecting the rules. They don't respect the norms on tariff. They don't respect the norm on technical barrier to trade. They don't respect the norms on sanitary and phytosanitary. They don't respect the norm on subsidies on agricultural products, and also they don't respect the norms on fishery subsidies as such. Although the latter is still going legalization as such. And the second one has been on the extent to which the substantive rules should be changed to capture the realities of our times. There's the substantive rules in the context of what was agreed at Uruguay, which is the whole WTO text, and then how these rules should be changed, altered in terms of the vagueness of some of the provisions, and then what can be introduced in the context of the WTO. Here I point to the one of the things that was actually early on in the negotiation, which I guess was in 1999, that was taken away from the WTO negotiation, which was the issue of the workers' rights, labor rights. The labor rights was taken off the WTO and pushed toward the international labor organization, because it was seen as not to be the proper forum to handle the issue of labor rights. And this actually has a very close connection to rule of law, how workers are treated multilaterally. So it is with that in mind that I am bringing forward the second contestation here, which is about the clarification and the improvement on existing rules. And then the third contestation is to do with the authority or power of the WTO adjudicating body, and more precisely the appellate body. Now we've seen that one of the challenges that has actually raised in the WTO has really been that some countries have been uncomfortable with the way the appellate body has been doing its job, because some countries feel that the appellate body members have gone beyond their power in terms of how they have engaged in interpretation and of the existing rules. So those countries feel that, oh, no, they are going beyond their power. And when they go beyond their power, it actually means that they will take decisions that are not reasonable, or I don't want to say unfair, but rather that decisions that are not in consonance with what the member state actually agreed at Uruguay. So that is why we have seen a lot of blocking of the appellate body. That's why the appellate body at the WTO is not functioning now. I mean, it does not exist at the moment. Since 2020, they have no appeal because there's no appellate body member. So that is the third and the last contestation that we have in the WTO that actually is linked to the rule of law. And while the challenges relating to the first contestation, that is members' behavior vis-a-vis the substantive content of the Uruguay Round Project, does not pose immediate threat to the future of the world trading system. So members' behavior in terms of violation, well, I mean, when you have international organizations, there may always be violation. And by and large, we've seen that countries have really respected the WTO rule. There are only rare situations where we see cases being brought forward at the WTO. Of course, I have to admit that there have been so many cases that have been brought forward. But this alone, to me, does not actually threaten the existence of the WTO. The second and the third ones are the two contestations that have paralyzed the world trading system. So in fact, the first and the second and the third one, in terms of how the reform in the WTO should be carried out, in terms of how the clarification should be carried out in existing rules, and then the issue of the appellate body power. These are the two contestations that have actually paralyzed the system. Because if it was just left to the first contestation, it's not a problem. They'll always bring the case to the WTO. So these are the two that have really, really paralyzed the system at the moment. So, however, I will try to end my presentation with a few thoughts on the third contestation regarding the WTO dispute settlement system, which has always been considered as the jewel of the crown in the cycle, in WTO cycle. So indeed, the WTO dispute settlement system epitomizes the rule of law, with more than 560 cases having been resolved through the system since 1995. The WTO dispute settlement is unmistakably a quasi-judicial system, or better still, an international trade court. I mean, this is a controversial that some members don't want to hear that, while other members are actually very happy for it to be called a court, because anyway, it acts like a court. The trust that the international community has on the quasi-judicial body means that even when the negotiating arm of the organization is continuously not delivering, the WTO dispute settlement system has remained the busiest part of this universal organization, and seemingly the only beacon of hope for the global trading system. Of course, this has changed with the non-existence of the appellate body, because now cases have already been treated by heard at the panel stage. Contemporary international scholarship and judges from other international organizations and tribunals have consistently cited the jurisprudence of the WTO dispute settlement system as persuasive precedent in various areas of international economic law. And in any case, how has acting in accordance with these rules contributed to the evolution of international law, because the international rule of law, because we need to see how they have contributed there. I will just mention a few examples. From the new principles and areas of coverage, for instance, the MFN, the most favored nation principle, and the national treatment principle are obviously international economic law principles that are emerging as part of customary international law. I mean, it's always customary now that even at any international level, when they start discussing something in terms of non-discrimination among members, they will use the terminology most favored nation, national treatment, and so on. These are international economic law principles. Moreover, we have now codified international rules in all areas of trade. The international law principle of partisan surrender has been invoked by WTO members and WTO panels and appellate body to reiterate the importance of their respect by nation states as subject of international. Moreover, the vast amount of jurisprudence elicited by the WTO dispute settlement system are also glaring contribution to the evolution of international rule of law, because these are very important in terms of the evolution of international rule of law. So those dispute settlement system has been cited broadly, even when you have situations where different regions, different WTO membership will enter into free trade agreement or regional custom union. They will always, if you have some few cases, as we have had at the level of the US, Mexico, Canada new trade arrangement, the former NAFTA, you always hear them, sometimes they cite the jurisprudence of the WTO. And you've seen this all around the world. And then we'll talk now about the kind of a bit politics. I mean, to end my presentation, say politics of the rule of law and the changing fundamental. So the contribution of the WTO adjudicative body to the evolution of international rule of law has also been instrumental in maintaining world peace and stability. Yet the recent events where WTO major trading partners have resorted to the old tactics of unilateralism threaten the very solid foundation upon which the multilateral trading system was founded. Moreover, the WTO appellate body, which has been a strong pillar of its most celebrated dispute settlement system, has been asphyxiated by some members who have blocked the appointment of appellate body members. It is hardly a secret that beyond the claim of excessive use of appellate body authority, the US concern with the WTO as a whole hinges on the substantive trade rules that the US and other WTO members see as outdated and leading to unsatisfactory dispute settlement reports. Yet, as Joe Weiler once put it, that was in his piece on the European Society of International Law blog in 2018, Joe put it as follows: one should be careful not to throw the baby multilateralism and the rule of law out with whatever dirty bathwater. End of quote. What is needed now from the US and other WTO members, in my view, is concrete demonstration that multilateralism is back, as President Biden has repeatedly said. So I think it's important now that there should be concrete demonstration that this multilateralism is back, instead of just saying it. But of course, if we look at the outing of the US trade representative in June this year, I mean last month, one would have a bit of optimism that actually the US may come up with some concrete proposals in terms of how to move forward with the negotiation. Because one of the things that the US trade representative raised in relation to this, and I think that was the first outing pointing out to the dispute settlement body, was that the US is not, paraphrasing, that the US now is not interested in procedure. Rather, the US is interested in substantive negotiation instead of procedural negotiation that has held up for a long time the multilateral trading system. So with that, I think one can have some optimism here that, in fact, the US and other WTO members will be able to come back to sit on the table and negotiate first to see how they can bring back the appellate body. We don't know the form that will happen, but they can bring it back. And then secondly, that the concrete negotiation on some of the other issues beyond the fishery subsidies that the ministers will be discussing tomorrow can be introduced at the WTO, because I think there is still a lot of scope there to improve the system, and the system has by and large served its purpose. And of course, it's not perfect. Many developing countries are not happy with some of the aspects of WTO. So as some developed countries are not also happy with other aspects. So in conclusion, I think again, it is more such concrete proposals that will actually bring back or reinvigorate the rule of law in the world trading system that can actually show that multilateralism is back. So I thank you.
Well, thank you very much. It was a great presentation, Professor. Thank you to show us some guidelines, I mean, some lights to the problem of the paralyzation of AB and the dispute settlement body of WTO. And came to my mind some questions that I would like to put here. in your opinion, at WTO, the rule of law needed to be guaranteed by the principle of single undertaking, as you have already told us, or in this era of delegalized, it needs to be modified, the principle of single undertaking? Do you think that if we broke the principle of, if you break this principle of single undertaking, and put a reform of the dispute settlement body, it would allow to back on track the system of dispute settlement of WTO? I think that one of the biggest problems that dispute settlement body is facing is the problem of the countervailing measures in anti-dumping agreement, the zeroing cases. How could you manage this situation with the United States? That's it.
Oh, thank you. Yeah, actually, yeah, I remember the question, actually the last part of your question, the question that I was asked, and it put me in a very difficult position when I was kind of campaigning for appellate body member. Remember the then U.S. ambassador to Geneva, Ambassador, I think it was Michael Ponk, asked me that question, not mentioning zeroing, but I knew that it was about a zeroing case because that was a bit of hot issue at that time. Yeah, so first, coming back to the idea of single undertaking, whether we should abandon this concept of single undertaking. I mean, of course, if we were to be thinking just saying that, oh, let's just see how we can move and appease other members to move this negotiation forward quickly, then, I mean, my cynical self will tell me that, yes, we should abandon the single undertaking and move on to the idea of variable geometry and as such, or maybe having negotiation and agreeing on certain issues and then bringing back some countries there, bringing back some countries on board. For example, I could have the negotiation going in the form of like TISA, the Trading Services Agreement that has been negotiated by some countries. And then once there is an agreement, then you can try to convince, use your diplomatic negotiation to bring other countries on board. Maybe this may sound like a kind of, one could say, a pragmatic way of actually moving forward with this negotiation. But I think there's a danger here if we abandon the single undertaking, because that idea of single undertaking was very important and has been very important in sustaining the multilateral trading system. Because if we were to abandon it, you'll have a situation where there will be different layers of WTO membership, different tier of WTO membership. So you have cluster of countries that have agreed on agreement X, you have like on services, and then others that have agreed on government procurement or on, say, or at worst on dispute settlement, while others have not agreed. So it will be a bit very difficult. I mean, variable geometry in this from this perspective, where a group of countries sit down and agree and then bring on board other countries, sounds like a very straightforward and pragmatic way to deal with this. But I think it has a lot of problems. There's a lot of challenges here that if you do that, because we are already seeing the situations here where it's a lot of developing countries and also least developed countries that have been complaining that the Uruguay round project, in terms of the WTO agreement, that the some countries, I remember I was working with some country, and then they said, well, really, we have to reopen the whole package because we signed up to something that we didn't understand. So we need to engage in a full negotiation because some of the agreement that were agreed went to our own detriment, and we don't think that those agreements are good enough and are protective of our interests. So if you think about this and what some of the smaller countries are saying, then you go forward again to enter into a kind of stages of agreement where some countries are on board and others are not on board. You try to convince others to come on board. Then it will be very difficult. So it's a good proposition, but I think it will be very challenging. But I think in terms of my view on how it's going to be, again, as somebody who has help a group of countries in negotiation. And it's one of the subjects that I have taught in terms of international negotiation. I think countries just need to know that they need to compromise. This is more about compromise. Multilateral system is never been easy, and it's never going to be easy. Because if you don't compromising in aspect of your sovereignty, then I think it will be very difficult to reach an agreement, because having a multilateral agreement is more about compromise. So if countries just make a little bit of compromise, then it will help. Now, one other thing has been the issue of developing countries. Yeah, you know, the classification of countries as developing countries. I think you have the US on the one hand, that is kind of competing with China, so to say, and China answering as a developing country. So it's very difficult there, for example, for the US to see how they will give concession to the same concession that they give to, say, a country like Peru, and then they give the same to China. No, because they just say, no, we are competitors. Why should I give you concession? So that idea of developing countries, I think some of the larger developing countries need to reconsider themselves that actually we should give up more. And that is where the sticking point is at the WTO. Many of those larger developing countries have not been really giving up more. And then regarding the other last part of your question, which was about the issue of zeroing methodology, I think the appellate body decided on that in terms of the zeroing methodology there at the WTO, that is kind of forbidden that to use zeroing in order to calculate the margin of dumping, because they think that it should be based on the market value and on the price, that the calculation has to take into account every consignment of the export. So I think I'm sure I haven't spoken to anybody from the US trade representative for a long time, but I'm sure the US now have gone over zeroing. They have now understood that zeroing is to stay. But of course, maybe that could be part of the reason why they want to renegotiate the WTO system. They want to renegotiate the whole agreement and the substantive element of the agreement, because somehow, I mean, I can see the US point in terms of the unfairness of some of the agreement to them, but I can also see that it is important that they also like make compromises. The compromise is the key here, I would think.
Yes, I totally agree. When I was in Milan, I was studying the spaghetti ball, many of regional agreements that was threaten the multilateral system. Now we have this agreement in the Pacific Ocean, leading by the China. In your opinion, do you think the multilateral system of WTO can resist of this regional agreement, RCEP?
Okay, yeah, thanks. Yeah, I mean, I think the multilateral trading system and the regional trade agreement, in fact, the regional trade agreement, well, like Article 24 of GATT 1994 and Article 5, plus the enabling clause, they were all inserted in the agreement for good reason. And the reason was very simple, that by countries coming clustering together as like-minded country and negotiating perhaps in new areas, it will actually create an opportunity for these countries to learn by doing themselves, to actually know a bit before they move into the multilateral trading system. So in other words, the regional trade agreement, they were all meant to be supportive to the multilateral trading system. But I think one of the problem now that has happened, well, which appears like a problem, is really that the current regional trade agreement, which are in the example of them being the mega regional trade agreement, this large one, the Trans-Pacific Agreement now, I don't remember the name, what it's called now, where the one that the US pulled out when the Trump administration, when Trump came to power. I think the Biden administration has indicated that they will rejoin that. I think when you have such mega regional trade agreement, think it will actually like take away attention from the multilateral system. Because countries, they will just feel countries that are party to it will feel that, well, we can literally just trade on the basis of this regional trade agreement. We don't really have to bother about multilateralism, where we have our so-called adversary there that do not want to compromise. We can just trade. But otherwise, I'm not usually totally against regional trade agreement, because I believe in the spirit of regional trade agreement, that it kind of help integrate countries, so that countries can be able to trade among themselves. For example, like in Africa, they have now what they call the African Continental Free Trade. The Continental Free Trade, I really see it as a very positive thing. But again, I'm also disappointed at one end, because I've seen recently that the EU, the European Union, has gone and signed agreements with individual countries that are party. For example, they were just negotiating one with Kenya. And then I've also seen that, sorry, I was talking about the United States rather than the EU. The EU has also signed individual agreement in the context of the Economic Partnership Agreement with some of the region, and some with individual countries as well. And the UK, now being out of the EU, has done the same. The UK is just going around those countries and picking them up and signing each individual agreement. So actually, this will actually fragment any benefit of this continental free trade. So I think, by and large, what I've just here to say about it, I'm just saying is that I'm not against regional trade agreement, because I think they really have positive side. But we just have to be careful the way we operate with regards to regional trade agreement. We should not kind of continue to expand this spaghetti bowl. Actually, some of them should be dismantled and sign up as a mega trade arrangement.
All right, great. Could you, if you don't mind, could you be back to the matter of anti-dumping measures and the calculation, the methodology of calculation of the dumping? Don't you think if the WTO changed the methodology of the calculation of dumping and put a rule of law, a limit to the option of countries to make their own methodology, could we change the cases of zeroing at WTO dispute settlement body?
I think, yeah, I think that is a very good point, that we can, in this such a situation where proper legalization happen in the WTO, that everything is regulated in the way that the negotiation on rules, which is the agreement on anti-dumping, is part of it, so that there will be provision there specifying exactly how the calculation was done, or prohibiting countries from instituting their own methodology. So if the way to do that, yes, that would be actually fine, because zeroing is one thing, and then the issue of state trading enterprises, especially with regards to China, is also another thing. For example, when it comes to the calculation of this dumping, there are some of the value of the product, in order to gauge the market value of the product for the purpose of the calculation of dumping. They don't look at the value in China. They rather look at what they call the surrogate country. And that surrogate country we're talking about here, they've been using, sometimes they have used India as a surrogate country to find out the real value. And then when they use that, of course, they will establish whether there is dumping. The product they are being sold in individual country is being dumped on the basis of the prices of such product. Because the state trading enterprises in China is kind of, it can be, the developed countries, especially the US, the EU, and then some other, Japan, for example, they find it very difficult to be able to compete, because on the one hand, those state trading enterprises, China see those enterprises as actually operating in the context of the notion of open market. in a sense, or in this market economy, not non-market economy, because China will see that more as a market economy in the sense that they think that those trading enterprises they are there profit maximization. They are there to make profit. But from the perspective of the West, they don't see it in that way, because they think that, oh, well, you say that they are there for profit maximization. What about the direct subsidies that you have been giving them? Because when you subsidize them, they don't compete. I mean, we cannot compete with them because they are benefiting from the state subsidy there. So it's a different view. I mean, I've had a discussion with a Chinese academic about this, and I realized that, I mean, they have a point in terms of how they argue it, but I also see that it's a bit problematic, the way that the concept of market economy operates in terms of being able to calculate whether a product is being dumped or whether subsidies have been provided or not. So I think this is an area that if it were to be regulated, if there was to be the so-called the rule of law in this area to regulate this area on how it can work, to specify that any operation in terms of any company that has to benefit or that operate within the context of the free trade should not receive any benefit beyond what is specified in the WTO from the state. Then I think maybe it may clarify the system. So I think yes, it's an issue that I think WTO members will have to handle to be able to move forward, because it's a point of division between China and the West, and that is one of the reasons why the negotiation has been held up.
Yes, I agree. One point that you put for us before is the problem of to break the single undertaking. I remember that would put us in the situation of gatti à la carte. Do you remember that before the Uruguay round? So I don't have any idea how to maintain the single undertaking. That is the great point of WTO that gave WTO the legitimacy and the possibility to put balance between countries inside the international trade system regulated by WTO.
Yeah, no, you're right. I mean, I think single undertaking is key, paramount to the existence of the WTO as a multilateral system. If they were to move back, as you said, to the a la carte system where there will be the country will pick and choose. Yeah, they will pick and choose which agreement to join and which one not to join. Then first of all, from a management perspective, it will be very difficult to manage the agreement at the WTO. And secondly, in terms of the rule of law and rule making, it will be so difficult. I mean, the WTO will be kind of a fragmented system there that does not work because you have countries that do not belong to one, to so many agreements. They pick their own and choose which agreement you belong to. So I don't think, for me, I mean, I wouldn't recommend that we should break the idea of single undertaking. Perhaps maybe what countries should be looking at in terms of the negotiation is kind of reconsider the decision-making process. The consensus decision-making process is good, it's important because it maintains the kind of the legitimacy of the system. But then maybe we could also kind of specify areas where decision can be taken, where there can be slight deviation from the consensus system. It can be taken by 3/4 majority of members. For example, we have the dispute settlement system that is kind of blocked now. I mean, the appellate body is kind of blocked. Nothing is moving forward. So if this was to be really considered by WTO member, perhaps maybe it can break the deadlock in terms of the negotiation going forward, because everything will hinge on how decisions will be taken. And that is the point that the US was pointing out there, that the US trade representative, the new one in June, pointed out that the US is not interested in procedure because procedure has held back the WTO. They are more interested in substantive issues. Of course, we are still waiting to get a proposal on the substantive issue that the new US administration has, because none has been presented. Again, they said perhaps maybe at the meeting tomorrow, I mean, tomorrow is about fishery subsidies, tomorrow the 15th, maybe after that meeting or at that meeting, they may also give some thoughts on how they see the dispute settlement going forward and the whole negotiation itself going forward.
Yes, yes. Many things to think about this problem. And last but not least, I'd like to go a little bit beyond your speech, if you allow me. And considering the rule of law as a notion of good governance, don't you think that the patterns created in the context of OECD would be predominant in the international trade system? We have here in Brazil Professor Vera Thorstensen from FGV. Vera is advocating the idea that the regime of WTO is being substituted by the regime of OECD. Do you agree with this?
Oh, yeah, thank you. Yeah, I don't know what the professors what she means by being substituted by the regime of OECD. I mean, it seems referring to the decisions that has been taken by the OECD, or is she referring to or is she referring to the adjudicative system at the WTO? So I'm not very familiar with the speech, but I don't think that the regime of the WTO is being substituted by OECD. I mean, it's true that very few members of the WTO are members of OECD, but I don't think OECD, in terms of their, let's say not the legality, but rather the legal nature of the decision that is taken and their report. I don't think their reports somehow, they make more of recommendation, isn't it? They don't make issue law. They don't issue like treaties that can be binding to members. And I think, of course, they do very good work because their work is very informative in regards to different areas of international economic relations. But I don't think that we could fairly say that their regime is is substituting the regime of the WTO as such.
Okay, thank you. Perfect. Okay, thank you very much. And now we have a question of one of our guests here. Thais is asking, good morning, Professor. Here we are in the morning.
Morning, yeah.
How do you see regional agreements like CTTP and RCEP, as I asked before, regarding to the rule of law and the WTO multilateralism? Well, something like that question that I have made before. Yes.
Yeah, no, I think it's true. I mean, as I said, I think the two regional trade arrangements that you mentioned, I think they are very big regional trade agreement. I mean, in terms of the trading, of the quantity of trading among the members, not in terms of numbers of the such agreement as such. On the one hand, I think I'm very much in favor of those regional trade agreements, so long as members can integrate properly and can sell among themselves, because I'm not a fan of the idea that neighboring countries do not trade among themselves. They're looking for markets far beyond their borders. I prefer that countries can first of all trade among themselves, among their neighbors, and then afterward they can look for markets beyond their region. So when it happens like that, it really helps to push forward competitiveness in the global trading system, because there will be a critical mass of the market in terms of market, and they can be able to trade abroad with other countries beyond their own border. But I think my challenge here with this kind of mega regional trade agreement is when they keep on diverting attention from the multilateral trading system. If countries see this mega regional trade agreement as substitutes to multilateralism, it's a very, very big problem. Because I don't think multilateralism nowadays, of course, talking about globalization is like a cliche. Because with globalization, you cannot just be trading with your neighbors. I mean, you trade with the whole world. A country, you interact with the whole world. So countries nowadays seem to have very little border when it comes to international trade. What is happening in, say, in the UK here can affect a lot of people in Brazil. And that is the nature of the international relation. So seeing it as a substitute, I don't think it's a good thing. It's not good for international relations, and it's not good for the world trading system. So, but seeing it more as being supportive to the multilateral trading system, then I think it's a great idea.
Okay. Do you have any questions?
Oh no, I'm fine. Yeah, fine. Thank you. Yeah, I just want to thank you.
I'm asking our students, our guests here, if they have any questions.
Okay.
No. Well, Professor, I can infer from your speech that WTO legal systems represent an expression of the rule of law in the multilateral trade system, as said before already, Miss Gabrielle Marceau, in one of her books.
Yeah.
And, yes, please.
Yes, no, I think, I mean, I agree that the WTO represents an expression of rule of law in the system, because when you see how the system is operating, even when countries do not respect it, they invoke the WTO provisions to justify why they cannot respect a particular provisions of the WTO agreement. So you see a system where countries always fall back to it, whether they are breaking the rules or other provisions, or they are respecting other provisions. So to me, it's really it's not perfect in terms of the crafting of the rule, how it is drafted, but I think that it's really a good expression of the rule of law. And I just hope that the Biden administrations and the Chinese and the EU, Japan, the countries like Brazil, South Africa, and India, those large developing countries, that they will be able to come back again together and see how they can move forward with the codification of the rule, because there are still a lot of areas that are not covered by the WTO, or that are still very ambiguous on the basis of the current rules that we have. So I hope that they can come together and then move forward in negotiations so they can be codified. So yes, indeed, I think it's more of an expression of the rule of law and the belief that countries have in the rule of law.
Yes. And I was thinking here that the concept of developing countries need to be changed. Well, maybe if WTO created the definition, because we have the developed countries and we have the least developed countries, but developing countries is many countries. So it's very difficult to create a balance between the developing countries, and even to establish more balance between countries in this situation that have, what I want to say is maybe to create new waivers to facilitate the access of markets and so on, something in this, a better definition.
Yeah, no, I think you're definitely right. I think that is a proverbial elephant in the room when it comes to the definition of developing countries. Because as I mentioned in my presentation, you have a country like China claiming the position of the developing countries. And then you also have a country like, say, Peru, or you have another country, say, like Cameroon, claiming the claiming developing countries. And what does it mean? This means, by claiming developing countries, it means that when it comes to negotiation, the kind of concession that developed countries, for example, like the United States or the UK or European Union or Japan or any of those countries, that the kind of concession that they will be required to give when it comes to the issue of agricultural subsidies, export subsidies, when it comes to the issue of anti-dumping, when it comes to the issue of technical barrier to trade services, when it comes to the issue of sanitary and phytosanitary, the kind of concession they will ask to give will be the kind of concession that will also benefit a country like China. So it's kind of somebody is telling you you are in a football field. And then they say that because you are a developing country, you should have 10 players. So you are competitors, but have 10 players, and then I have 11 players in the field. So they say, okay, go and compete. I'm sure myself with 10 players, I will not be happy if we are competitors. But if it was to be like, well, we are in a league where we know that we are professionals, and then we have like a very amateurish league, and they said, okay, let's leave them to have 9 players, and we have 10 players, and then we are 11 because we are professional. And I think we will still win them, even if they are 11 and we are 10. Then maybe that one, me with 10, I can understand. But if we are pure competitors, all in professional league, when it comes to trading, I don't think I will be happy to accept that. And that is exactly what is happening at the moment. I mean, there are aspects of the economy of China that is still developing, for example. And I think the same holds for, I would say, kind of countries like Brazil or countries like South Africa, Mexico, in comparison to other smaller developing countries. So this definition, I think they need to be a way of finding or kind of dividing this developing country. They need to be bigger, larger developing country, and then the smaller developing countries in terms of concession at the WTO. Otherwise, it will not work. If we just have developing, least developed, and then develop, I don't think it would work. Otherwise, what the WTO member can agree, they can agree to say that, oh, well, country X, why don't you, for the purpose of the WTO, we understand that your country still face some challenges. For the purpose of the WTO, you are a developed country. We consider you as a developed country, or more or less you take obligation almost the same like us developed countries, so that we can be able to give concession to these smaller developing countries to make them to integrate. So in that may make sense. But if you don't have such division, if it continues to exist as this, then it will be difficult for any agreement to be reached.
Yes, I totally agree. Well, Professor Amina, Fernanda, do you want to make some points, or can we finish?
Lucas wants to make a question. He has his hand raised.
Okay.
Professor Amina, and first of all, thank you, Professor. I'm sorry, I don't know how can I pronounce your last name.
It's Ngangjoh. It's fine.
Ngangjoh. Yeah, thank you. So my question is about the appellation body. Considering our scenario now, the pandemic scenario, and brief this, but the current scenario about the WTO in general, how can you see the future of this body, this appellate body? Oh, it's a simple question, but I recognize the complex to how we can answer this, but you as a professor and a specialist in this theme, I would like to know about it. Thank you.
Okay, thank you. Thank you, Lucas. I mean, that's like a $26 million question. So, I mean, I wish I would know. I wish I could know what it is. But I think for me, I'm always an optimist. I feel that whatever the situation, I think the old GATT 1947, from ITO, International Trade Organization, to GATT, it went through a very difficult period. And it went through difficult period and challenges. And the way I'm seeing now, I still see some positive there. I think that countries' common sense will prevail, that countries will come back and sit around the table and negotiate the appellate body, to reintroduce the appellate body. Perhaps, sometimes I always say, like the cliche in English says that disappointment is a blessing. Perhaps maybe the issue that happened to the appellate body in the blocking of membership of the appointment of appellate body member is actually some sort of a blessing. is that you allow members to rethink how this appellate body should be going forward. I think some countries have raised, have put forward some proposals, because they want that the appellate body should be permanent, and they want to either increase the number and making them permanent. That is one proposal. The other proposal is that they want the appellate body to have a fixed term, so that there will not be this problem of blocking in future. They have the one appellate body member should have like an eight years fixed term or 9 years fixed term, instead of having this 4 years fixed term. So I think all these proposals in the end, they will reach at a consensus. The countries will reach at an agreement there. So I still believe that the appellate body will come back. Yeah, although since 2020, no appeal has been made. And I know that the EU has been very much, and other countries have been very much, the European Union has been very much in favor of the arbitration. They have actually been kind of nominating individuals for this arbitration system. But that's also another alternative that countries have proposed. But I think in the end, the appellate body, as we knew it, may come back, of course, in different form. I think it will likely come back to me. I don't think that the appellate body itself is dead in water. I think it will come back.
Yes, the $5 million question.
Yeah.
Thank you. I appreciate it.
Well, any more questions? Professor Amina?
No, I think it was a great lecture. We don't usually have these dialogues about economic issues, so it's very interesting to have a professor that is willing to talk about it. So I thank you very much for your time and your availability. Thank you.
Okay, thank you very much, and thank you for inviting me. Thank you. Yeah, thank you. Okay, bye.
It was a pleasure.
Thank you, Professor.
Thank you. Yeah, bye. Okay, bye.
Thank you all.
Thank you.
Thank you. Bye.
I see you all in this afternoon.
Okay, thank you.
Okay, thank you.
Bye.